and welcome to one more edition of Capital and Lectures with me, your teacher, Santosh Baliga. Today, in this lecture, we are going to focus on equity shares with differential rights. What do you mean by equity shares with differential rights? We have already discussed in my previous lecture where I had discussed about Section 43 and classification of equity shares. There were two types of equity shares. One was plain vanilla equity shares, or you can also call it as ordinary equity shares with voting rights, and the second was equity shares with differential rights. Normally, differential rights are with regards to dividend or voting rights. And normally, in practical instances, you would find many differential rights equity shares are with voting rights. Hence, they are normally known as DVRs. DVRs, if I give you an example of DVR, then you will come across the most common one will be of Tata Motors. Tata Motors has its ordinary equity shares as well as its differential equity shares as Tata Motor DVR, which is listed on the stock exchanges. Now, can every company issue equity shares with differential rights? So, the Companies Act under Section 43, read with Rule 4 of Companies Share Capital and Debenture Rules 2014, ensures that there are some conditions which are required to be fulfilled if the company wants to issue equity shares with differential rights. What are these conditions? Let us go through it under Rule 4. The first normal condition which is there, which is a common condition which has to be fulfilled, is that the Articles of Association of the company shall authorize such an issue. Articles of Association of company shall authorize such issue. The second point would be issue of shares in case of issue through differential rights shall be decided by the company through an ordinary resolution. And such ordinary resolution shall be passed in the general meeting of shareholders. So I hope you have understood this. Any decision that the company takes has to be taken through an resolution. And in this case, the resolution will be ordinary resolution in general meeting. So the Companies Act under Rule 4 is extremely specific that an ordinary resolution would be sufficient. Second point is, if the company is listed company, if the company is a listed company, in that case, it shall be approved by shareholders through postal ballot. It would be ordinary resolution through postal ballot. If the company is a listed company. Okay. This is important. Do remember this point. It may come in the case study purposes. Okay. The next point is such voting rights in DVR shares. Such voting rights in DVR shares shall not exceed 74% of total voting rights of the company. This is a recent amendment which is made. Hence, it is important from examination point of view. So, the total voting rights through DVR shares shall not exceed how much? 74% of total voting rights of the company. I hope this point is also clear. Next point is that the company has not defaulted. Company has not defaulted in three main points. One, filing of financial statements and annual return. In which section do we file annual returns? We file it under section 92. I have uploaded a video on section 92, filing of annual returns. Do check it out by just searching on my channel. I think it is my first video. So you can go and check that video and get conceptual clarity about filing of annual returns also. Okay. Now, the company shall have not defaulted in filing of financial statements and annual returns for 3 financial years, for not just one, not just two, but 3 financial years immediately preceding the financial year in which they have decided to issue such shares. Okay, so this part is also clear. Secondly, the company should not have any subsisting default, means current default in payment of declared dividend. If a dividend is declared by the company is going to give 5% dividend, then after declaring it, there should not be any default by the company in payment of the dividend. Secondly, if the company has issued any deposits to deposit holders, and at the time of maturity, if the company does not or defaults in repayment of such matured deposit, so then in that case also, the company will not be able to issue DVRs. Thirdly, if the company at the time of maturity of the preference or redemption of the preference shares or debentures is not able to make it, is defaulting in making the redemption of preference shares or debentures or any interest on it, or any dividend that has to be paid on the such preference shares when it is due, in that case also the company will not be able to issue DVRs. Okay, so same point is given over here. Next, the payment of dividend. In case the company defaults in payment of dividend of preference shares or repayment of any term loan, from any public financial institution or state level financial institution. Only from public financial institution or state level financial institution or any scheduled bank which has become due. Such loan has become due and the company has defaulted in it, then the company will not be allowed to come up with equity shares with differential rights. Also, if the company makes any default in payment of statutory dues. What are statutory dues? Statutory dues are dues which are required to be paid by any law, like under Payment of Gratuity Act, Payment of Wages Act, Payment of Employee Provident Fund Act. Okay, so PF, ESIC, contribution or contribution towards gratuity. If the company defaults on payment, making payment or crediting to such accounts of the employees, or any statutory dues are defaulted by the company will not be able to make issue of differential rights equity shares. Also, in case the company does not make or does not create an amount to the IEPF, IEPF means Investors Education and Protection Fund, to the central government. I will discuss this IEPF concept in detail when I go through the chapter of dividend. It is covered up between section 123 to section 127, specifically under section 125. If the company defaults in creating the amount to IEPF account, in that case also the company will not be allowed to issue DVRs. So there should not be any default in these matters. What are these matters? Filing of financial statement, annual returns, any subsisting default in terms of declared dividend, repayment of matured deposits, redemption of preference shares, redemption of debentures, any interest on it, payment of dividend of preference shares, or repayment of any term loan which has been taken through, which is due, which has been taken from public financial institution, state level financial institution, or any scheduled bank, or the company defaults in making any payment of statutory dues in terms of crediting the amount to IEPF account. Okay, this part is clear. Now, if the company has defaulted, then the company will be barred from making such an issue. But the time frame, 5 years from the time when such default was made good. That is, in case say the company has defaulted in one of these things, company has defaulted in say redemption of preference shares, okay, and this default has happened in 2019 to 2020. Now in 2020-21, the company pays this default and makes this default good. Default made good. That means the company has paid to the preference shareholders. Now, from here on, the company will have to wait for 5 years. 5 years from the end of the financial year. From the end of the financial year means it will start from 2021 to 2022 to 5 years for issue of such differential voting rights equity shares, that is DVRs. So it is quite stringent, quite strict provision over here. So the company would never want to do any such defaults. Okay, this point is clear. Now, the last point is the company has not been penalized, for any offense, during the last 3 years, under RBI Act 1934, under the SEBI Act 1992, and under the SCRA Act 1956, the FEMA Act, Foreign Exchange Management Act 1999, or any other special act under which any regulator has come up with an act. Okay, this is clear. So there are 7 conditions which we have gone through. Now, one more important point that I want you to note over here is that if any company has issued an equity share with voting rights, these are plain vanilla equity shares, ordinary equity shares, then the company subsequently cannot convert it into equity with differential rights. And vice versa also, if the company has issued DVR, then the company cannot convert it into equity with voting rights. This point is important. Do remember this point. This whole rule 4, that is conditions of DVR, is extremely important topic from examination point of view. If a direct question comes, if a case study comes, it does come on this particular topic. So if you have understood this particular topic, do ensure that you like this video, share this to the maximum of your friends or groups, and if you have not yet subscribed to this channel, do subscribe to this channel for the complete lectures of CA Inter also. Okay, so thanks a lot. Stay safe, stay healthy, stay happy.